Hello, ladies and gentlemen, veterans, dedicated VA employees. Welcome back to the channel. I greatly appreciate you coming back where we talk about VA disability. Hey, as always, I'm attorney Matthew Lang, VA credit attorney. Here we are the day after the Veterans Day holiday. Veterans, thank you for everything you do and have done. I hope you got the opportunity to get out there and enjoy the festivities that may have been in your communities and to also enjoy all that fine food that came from so many different restaurants. I'm going to dress down today, as you see. It's still a holiday. Figure it's a good time. But I'm definitely still back here working hard for veterans and getting the benefits that you're entitled to. As today's discussion, I'm going to talk about reduction in compensation benefits. This is going to be an overview because I need to set a foundation, I feel. This is a topic that has so much law behind it that I think it creates more errors sometimes because of a lack of understanding of some of that law, or even a majority of it. But there are definitely legitimate times, veterans, that your benefits can be reduced, or your monthly compensation payment in particular. So I want to go through a few of those, keeping in mind that pretty much all these can be broken down into other videos and probably even multiple videos in the process. So what is reduction in compensation benefits? Well, in short, veterans, this is when the VA decides to decrease your amount of monthly compensation payment. There's definitely multiple reasons for such. We could have improvement in your medical condition. It could be shown by the evidence. I'll talk a little bit more about that one here because it's pretty common. It could just be something as simple as dependency change. So you got a change in criteria of law. Veterans, as you may know, 30% is the minimum threshold to start receiving payment for your dependents, your spouse, your children, dependent parents. Children get older. They become adults themselves, and they may fall off your award because you're no longer meeting that criteria of them being, well, a dependent child. Same with the spouse. If there's a divorce, for example, and you don't get remarried, there's no benefit for the spouse because you no longer have that dependent. So that changes the monthly compensation amount. Those are just ones that are done with outside of an actual what they call rating decision because just the change of status. Those are pretty common. The other one that I have on my list is a reassessment of disability rating or a reexamination, future exam, you may hear me call it. This one here I'm going to talk a little bit more about, but again, this can have a whole section by itself. But I'm going to lump it into that improvement in medical condition because they really overlap. Another reason could just be that the code, the federal code, just dictates that say 100% is only temporary and it should be reevaluated and reduced, and that's going to kind of come into that as reassessment as well. But sometimes just the law says, hey, it's not going to stay there forever. Typically in cancer cases on that one. We also have stipulations in law that talk about clear and unmistakable errors, CUEs or Qs as they're called. This, again, really big piece to talk about, so I don't want to go into really detail in this video. But to help set that foundation for it, I want you to know, veterans, that a CUE is essentially a error that is so clear that the VA should not have made it based upon facts of the case and laws at the time that the decision was made. So it is possible that the VA will grant you some benefits, veterans, or an evaluation, and it's incorrect. They catch it later on down the road when they do a review of the file, whether it be for the same condition, maybe another condition, and they go back and they fix it and they call the CUE. I'm definitely going to leave it again for another time. That's the basics of it because there's different definitions in there that we'll legally argue about because the law is unfortunately kind of vague with that piece. Because again, law can't be black and white. It can't give you every clear definition out there. Just things like reasonable person, undebatable, so forth. So a big part for another time, but veterans do know that errors do happen. these CUEs could ultimately reduce your benefits if caught later on down the road. But it's not, CUE should not be always seen as a negative thing either. Just, it's in this example as a reduction, but it can also give you benefits to veterans when the VA mistakenly denies you underneath the CUE. So that is also an option out there for reduction. And I think the biggest one ultimately is just VA mistake and error, just simple mistakes, errors, not understanding a concept, not thinking about it, not reviewing all the evidence happens quite often, maybe doing what they call top sheeting. And we'll talk a little bit more probably on that with the other piece here I've left aside. Unfortunately, it happens. So there's definitely some mistakes, and it could cause a reduction in benefits veteran. So let's talk about that improvement in medical condition and that reassessment piece. So thinking of reassessments. So this is what I hear among the veteran community, is there's a lot of concern that the VA can come back and reevaluate, reassess veterans your conditions. They can't do it though just for fun or just because they feel like it though. Can they? Yes. So what's got to be looked at is, one, is your condition determined to be static? Static in short, meaning that it's permanent in nature. So if your condition is permanent in nature, the VA is not likely to reassess or reevaluate on their own in the future. But if it's not deemed static, veterans, there could be a review in the future. The criteria in short for the VA to determine whether a condition could improve or likely is to improve, or substantially improve, honestly is the terminology there, is if the evidence is clear and objective, there's objective and clear evidence at the time that this likely that your condition will sustain improvement. Now, keep in mind, and this is for both sides, veterans and VA, that conditions do wax and wane. They go up and down. Some days will feel better than others. It may look like improvement. Other days are worse than others. Those are not sustained improvements. Those days where things just magically feel good or better even, just by a little bit. There's a lot more really into that, and unfortunately we're not really going to hit all that here because, like I said, these can be all these topics can be put into their own long videos or multiple parts, and that we'll get to, but just to get that foundation in there. But veterans, the idea here is that if your condition is deemed not to be static, the VA could put this future exam on your claim for that reexamination or reassessment. Now, they still have exceptions in the law because that's what's fun about law. Nothing is black and white. There's a rule and there's an exception. There might be another exception to the rule. There might be another exception to the exception. Could be an exception to the exception to the exception. And I think that's what sometimes makes law a little bit tricky. So veterans, if the VA says your condition is not static, they do feel that there's objectable, clear evidence in your file to say that there's going to be sustained improvement, they may still not be able to put a future exam or a reevaluation on your case. We're going to find in 38 CFR 3.327, I'm going to highlight that one, veterans, for you to go back and kind of look at, because there's a short list in here of different things. I'm not going to hit them all, and a better definition of what we're talking about for these reexaminations. But if veterans, for example, one of these other things on the list is if you are rated at the prescribed schedule minimum rating, in many cases, that's a 10% for the condition. Even if the VA feels that there could be improvement to that 0%, that 10% is the minimum scheduled evaluation, then no, a reassessment cannot occur. So that there alone may prevent you from having a reduction in the future, just this little piece here. The other one I'm going to mention here is because I see veterans talk about it a little bit more often, And it's the idea in here, the CFR also says that no additional re-examination or evaluation in cases of veterans over the age of 55 years. So a lot of misconception, I think, with that sentence, because there's another half I've left off so far. And again, bigger video for this, but you're not untouchable veterans when you're 55 or older on potentially having your veteran disabilities, your VA disabilities reduced for reexamination. The main rule says no, there should not be a reevaluation, so you really can avoid that off the main rule. But right behind it, the word except shows up, so the exception is right there in the same sentence, except under unusual circumstances. What does unusual circumstances mean? Definitely for another day, because we're going to dig a lot of case law and so forth on that one, because it's a very vague spot, I feel, in the way the law is written there. And when we dig through the manual, VA manual, we find a lot more vagueness as well to it, and some vagueness that's concerning to me, but again, another story, another time. The idea here, though, as veterans, is your reductions are possible on these future exams, these reductions, but there are still exceptions that could prevent those future exams and reductions from occurring, even if those reassessments would, underneath the black and white piece of the law, we'll call it, is met. So I bring a lot of this up for different reasons, but one main thing to look at is, I think this is where some of the errors that occur on the VA part is that they miss these exceptions. They may not realize they're there. They get into certain habits or routines to following just the black and white rule. And then we've got future exams that reduce benefits when they never should have existed. It's sometimes an issue there as well. The improvement in medical condition really also comes down, can be shown again through those evaluations, those future exams. So veterans, when I say improvement in medical condition, I'm not just talking about those, the future exams that the VA schedules through their contractors and VA down the road based upon your substantial improvement. The idea here is that you, veterans, could submit a claim for increase because I would say by medical definition, your condition's worse. And that could prompt a VA exam. And that VA exam could come back as your condition is not worse by definition under the law. And that's just another interesting part of this field, is we have really two pieces that have to come together. We have a legal piece and we have a medical piece. And sometimes those don't really talk well. Almost all the time they don't talk well with each other. So what I mean is veterans, you may go, boy, this condition is just, the pain is so much worse. I can't do what I used to do. Whatever the symptom may be, sure, it's worse. But keep in mind, things like even joints, the law is focused only on really range of motion for the most part. There's definitely other pieces, but let's say the back condition. Range of motion is huge for a back condition or a spine condition of sorts. So you may file a claim for increase because medically it feels worse and it is worse, but legally that exam comes back and says, no, the range of motion is better, so it's not any worse. So that could create a showing of improvement in your condition, veterans, and then lead to that reduction in your benefits. The error that I'm going to say VA that may show up there is the idea that just because there's one exam that shows improvement, whether it be within this 5-year rule line, like before 5 years in another section of the law, doesn't necessarily mean that there's sustained improvement. We do have to remember that conditions wax and wane. Some days are worse than others, and that it is possible that the exam is only catching the veteran on one of those better days, and it's not a full picture. Maybe maybe the exam is inadequate, which is a high possibility, especially unfortunately with those VA exams. It's just another error that the VA has faced year after year. Maybe it's not accurate. Maybe something wasn't done when they say it was done. I don't know. Could be anything. I don't want to beat it up too much because it's not always the case. But veterans, the point there is that improvement could be shown by a single medical exam, and it may not. You may have other evidence in there that shows improvement in your file that's obtained, and that could be enough as well to create a reduction in your benefits. Now, there are other rules out there. If you really want to determine that your benefits can't be touched, veterans, there is a 20-year rule. So if that benefit or that evaluation has been in effect for 20 years and you go in for that increase and that shows improvement, well, it's not coming down. Unless, again, an exception, showing a fraud or some sort from the original assignment. But again, full different other stories there. What I want to leave you with, though, is the idea that reductions can happen. There are spots in the rules for a reduction in benefits, a reduction in monthly compensation payments, whether it be dependencies, medical evidence showing improvement, reevaluations, these future exams showing improvement, whether the VA just makes a mistake and does a reduction. So there we got reductions that shouldn't occur, but they do, unfortunately. It's just something to be mindful of. It's something that we can look at better down the road here after this little foundation, especially dig deeper into, understand some rules and regulations, and avoid a lot more of those errors that occur along the way. So anyhow, again, veterans, thank you for your service. I do hope you had a wonderful Veterans Day. I'm going to make this a fairly short video in comparison to the last few of them I've done, giving you this foundation of reduction in compensation benefits. But if at any time, veterans, you get that proposal to reduce benefits, or you do have a decision that reduces a benefit, please do not hesitate to seek representation, especially through myself, veteranlang.com. You can click my link there, get a free case evaluation. We can talk about your case and see if the VA did make a mistake. Did they do it wrong? Do we need to have a hearing? Do we need to take it further and keep those benefits that you deserve? Other than that, don't forget to like, share, and all that other good stuff, everybody, to keep this word out there and continue building this platform to help each other out, both VA and veterans, to make that smoother transition. With that, I bid you farewell and have a wonderful day.